Good day to all. I am Advocate Pradeep Shukla, practicing at Bombay since 48 years, और डीलिंग विद द प्रॉपर्टी मैटर्स बहुत पर्टिकुलरली मैंने बहुत सारे जजमेंट देखे, पर आज जो मैं जजमेंट अपलोड कर रहा हूँ इन माय यूट्यूब चैनल एडवोकेट प्रदीप शुक्ला पे, एक यूनिक जजमेंट है जो हर एक इंसान हूसोएवर इज द लिटिगेंट उसको हेल्पफुल हो सकता है। ये शॉर्ट में फैक्ट्स बोलूँगा तो ऐसा है कि देयर वाज ए रिटर्न एग्रीमेंट बिटवीन द पार्टीज in respect of the purchase of the land. Substantial amount was paid, and then the purchaser also merged the property with the adjoining land to develop the same and spent lot of money. But in the agreement, as per the Transfer of Property Act, there was a part performance to be completed by the purchaser also, which was negligently avoided or deliberately not done with. So this was the case. Since the dispute was there, the purchaser filed a suit at the Allahabad High Court and obtained an ex parte injunction of status quo against the seller of the land. Now ex parte injunction, court has a power. ऐसा नहीं कि power नहीं है. It's a rare among rare case where the court grants an ex parte injunction without hearing the other side. Now, if such order is granted, the order 39 of CPC, it is mandatory for the judge granting such order to record the reason why ex parte injunction is necessary to be granted, what is the balance of convenience, what can be the hardship caused if the injunction is not granted ex parte. And that also, if the notice is issued and time is wasted, how the parties claiming it will be affected. These are all compulsorily to be noted in the judgment. The trial court, without considering and without mentioning any of such reason, grant the ex parte order of status quo, thinking it's a status quo order, it should not affect anyway. Anyway, what happened was that the defendant preferred an appeal in the High Court, by Allahabad High Court, and in the appeal the ex parte order was declared not legal and it was not granted, means it was set aside rather. Against that also appeal was preferred at Supreme Court. Now this is more important. The Supreme Court also upheld the judgment and said that yes, such an ex parte order is not tenable in law. There has to be compliance of the. Now Supreme Court has read the entire proceedings. The entire plaint do not contain any elements of specific performance of the agreement. In detail, Supreme Court going through entire pleadings, it was found that actually the suit has to be a suit for specific performance. Not a word was stated about that. It was just on the basis of that they have spent money, they have entered into agreement, huge amount is paid, and then it was presumed that the legal possession has been passed on to them and ex parte injunction order was granted. Considering all this fact, even the Supreme Court rejected, confirmed the plea of the defendant that ex parte injunction needs to be vacated, and that way this judgment has become very important. I'll just give the citation of the judgment. It is party's name is Time City Infrastructure and Housing Limited at Lucknow versus State of UP and others. Now this judgment is given by Division Bench at Supreme Court, J.B. Padiwala Judge and R. Mahadevan Judge. Now this judgment is delivered on 11th August 2025 in a special leave petition number 21747 of 2025. Now anyone who wants to know detail about that, visit the judgment, my YouTube channel, or otherwise can ask me on my personal mobile number 932 369 1755. Yes, it is a fact that I generally charge consultation charges But for such inquiries, I will not be charging anything to the person who wants to know about it. Thank you.